Hi, I'm Emma Salmon. I'm a solicitor here at Whitehead Monkton in our Contentious Probate team. I'm here alongside my colleague Sam Corse, who's a legal executive also in the team with me. What we're going to do today is just go over a case study that Sam has helpfully prepared in relation to a claim under the Inheritance Act. Sam, did you want to start by summarising the case study for me?
Yeah, hi Emma. So the case that I've got here is we've got a wife of a deceased. She's recently obtained a copy of her late husband's will, and she's discovered that the will doesn't make any provision for her, it doesn't leave her anything at all. The estate is left to his 3 children from a prior marriage under the will. My first question is, can the wife do anything about this?
Right, okay. So there is a potential route that she could look to pursue an action here, which is under the Inheritance Provision for Family and Dependents Act 1975. This act is in place and lists certain people who could pursue a claim, and a spouse and a civil partner do qualify under this act as a claim that they could potentially pursue.
You mentioned the act then, and who can bring a claim. What the grounds? So what the grounds for applying under the act, bringing a claim?
So what the wife would need to do is show that reasonable financial provision has not been made for her under her late husband's will. So here, obviously, you mentioned that the will did not make any provision for her. So it would just be whether or not that no provision situation is actually reasonable in the circumstances. Here, as it is somebody who is a spouse, the position is that there's a slightly lower threshold that she would need to prove. So for certain applicants, they would need to show that reasonable financial provision needed to be made for their maintenance, whereas here, as a spouse, it's just reasonable financial provision in relation to her circumstances.
Right, so what does she then need to prove that, to show basically that she hasn't received that reasonable financial provision for her circumstances? Is there anything in particular that she needs to prove?
So there are certain factors that the court would be considering, and the primary aspect here would be what her financial position is. They would also be looking at the deceased assets, so the extent of the estate that's available. Here, because it's a spouse, what was the length of their marriage, and would potentially be looking at what would happen if they were to divorce, rather than their marriage end on the death of her late husband. The court would also take into account the circumstances of the beneficiaries. So here, the 3 children from the prior marriage, what their financial positions are as well, and not just her own. The court would also consider any health issues as well that perhaps the wife has, or any of the 3 children who are set to receive under the will at the moment.
So there's a lot.
There's quite a variety.
Yeah. Just going back to sort of the facts, let's say that it's relatively early, that after the death, that she's come across this will to find out she's not receiving anything. Is there anything timescale wise that she needs to bear in mind for bringing this type of claim?
Yeah, so there will be a timescale that she does need to bear in mind. It's not an immediate deadline, and so I appreciate in circumstances, if someone has just recently passed, I wouldn't want them to panic that they have to take action immediately. However, it's important to keep an eye on any relevant time limits for bringing this type of claim. And here, the next step would be for the executors, so those that need to prove the will and administer the estate. They will be applying to obtain the grant of probate, and so it's 6 months from then that the claim has to be issued.
Right, I see. I suppose the main issue, and sort of the main question also, is a question of costs. Is it expensive to bring this type of claim?
So litigation is a very costly and timely matter to take on, and so it's really important that people do bear that aspect in mind. In terms of timescales as well and how much it's going to cost, it's always going to be quite difficult to provide estimates. But what we do is really try to encourage people to consider alternative ways of trying to resolve their claims rather than taking the time and expense of reaching the point of trial. We try to look at how this can be resolved sooner rather than later.
Thanks, Emma. And if for anyone listening, if there's any further questions you have, or if you find yourself in a similar situation to this, then please don't hesitate to get in touch with Emma or I and the Contentious Probate team here at Whitehead Monkton.